Hey guys, welcome to our lesson on Chapter 2 of Adamson's Law for Business and Personal Use, preparing you for the Business Law Objective Test FBLA competitive event. Let's start with the types of positive law. So there are four main types. The first is the Constitution. This can be at the federal or the state levels. Many local governments also have either constitutions or charters that have a similar purpose. And so the constitution or charter of a certain government is basically the fundamental document and law of that government. It outlines the basic structure and creates the main authorities of that government. The U.S. Constitution, which is the Constitution for the federal government, splits power between various parts of the government, which are the three branches of government: executive, legislative, and judicial, and the separation of powers. It describes how different powers are located in different parts of the government. For example, the executive has the ability to and the power to put the laws into effect and enforce the laws. Legislative has the power to make the laws. The judicial branch has the ability to interpret the laws. And there's also checks and balances. And checks and balances are basically the idea that each branch is able to check the other branches in their execution of their own powers. For example, the legislature may pass a law, but the executive can veto the law, or they can decline to enforce the law, or the judicial branch might make a ruling on or interpretation of the Constitution or the statute, but then the legislature can just change the statute or change the Constitution. So that is checks and balances. And then we have the different levels of government, the splitting of power between different levels of government from the U.S. Constitution. That really is the 10th Amendment, which outlines that any power not delegated to the federal government goes to state government. Or state governments. There are 50 state governments. And then the U.S. Constitution also splits power between the people and the government. That's really the 9th Amendment, because the 9th Amendment says that there are other rights outside of those that are given to the federal, outside of those that are explicitly designated in the Constitution. You also have things like the Bill of Rights in general, which provide various rights and protections to the people that the government can't infringe upon. And then we have statutes. Statutes are basically what you think of like ordinary laws, civil rights laws or environmental laws, right? When we talk about, the lawmaking procedure, like how the House, the Senate, and then the President pass a law and then the President signs it. When we talk about that process, we're talking about how statutes are made, how ordinary laws are made. And at the federal level, we know the procedure for making a law. The House and the Senate each pass the law by majority vote, and then the President signs it. The President vetoes it. Then both the House and the Senate, if they pass it again with a 2/3 vote, then that becomes law, even though the President didn't sign it. However, in many states, the lawmaking procedure may be different. There may be different majorities required to pass a law. Some states have the power of, there's something called the power of referendum, where voters can draft a law, propose a law themselves. They can get a number of signatures, submit those signatures for verification, and then if they meet a certain threshold for signatures, then there can be a public vote on whether that proposed law should become a law. Some states, the Constitution can be amended, the state Constitution can be amended a similar way, and yeah. So really, statutes are made are made under the authority of the Constitution, because the Constitution describes how the statute should be made. Like, for example, at the federal level, the U.S. Congress has the power to make statutes, not just because it exists. It has that power because it's described in the Constitution. Okay, so then we have administrative law. Administrative law consists mainly of regulations that are made by administrative agencies in the executive branch. Like, when you think of the various cabinet departments at the federal level, like Department of Homeland Security, Department of Justice, Department of Health and Human Services, Department of Energy, even the some of the regulatory agencies like the Environmental Protection Agency and so forth. So oftentimes they'll have limited powers, legislative and judicial, delegated to them by the legislature. The reason that Congress, in the case of the federal level, does this is because they may not have like all the expertise that many of the employees of the executive branch have, so they will delegate the power to create some limited regulations to the administrative agency. For example, like the Social Security Administration has the power to set out certain rules on how it'll distribute the benefits that it's required to distribute under the law. It'll also have a limited judicial power because it can hold hearings, for example, to apply its rules, to apply the law, to see who is to see in a specific case whether or not a certain person is entitled to his benefits. And of course, all of that can be appealed to, the normal judicial system. But the point still stands that administrative agencies usually have some legislative and judicial powers are delegated to them by the legislature, in addition to their executive powers that have been granted by the statutes, or in some cases, usually the state level, the state constitutions might also give administrative agencies certain powers. So then we have ordinances. So ordinances are local laws, basically created by a county or a city or something like that. And the process for making an ordinance can vary depending on the structure of the local government, and because the local governments are creations of their states, the state law, the state statutes, and the state constitution sometimes might describe certain ways that ordinances have to be passed under. So they have to go through some procedure in order to pass an ordinance, and the state statute will outline that procedure. So let's talk about some other terms related to the law. So civil law really describes the law relating to when certain court cases are decided, and the court cases are between two different legal persons. And when I say legal persons, I'm saying that not only includes human beings and so forth, but also businesses or corporations, because they have certain limited personhood when it comes to the law. So civil law is basically when two non-governmental parties are suing each other, and the law that's created out of those lawsuits, or law that's created by legislature regarding those kinds of lawsuits, is considered civil law. So criminal law is when the government seeks remedies against a legal person, not always, but because the government can still sue you as a matter of civil law, but criminal law really occurs or is created when there are suits where a person is alleged to have violated a certain statute by committing a crime that has been designated by that statute, and those crimes can result in potential punishment, such as fines, imprisonment, or death, depending on the severity of the offenses. Death penalty exists in 23 state court systems so far. It also exists in the federal court system and the military court system. So procedural law is is a term that describes really the law relating to the legal system's architecture, its infrastructure, all of the all of this, the whole system of that is there to implement the law, whether that's the executive branch agencies involved in enforcing the law, as well as the judicial branch which interprets it. It also describes all the procedures that parties have to follow. Business law is just a broad term that describes a law that relates to commerce, but in general it mainly deals with civil law, and namely contracts and tort law. But there are also certain criminal offenses that are closely related with business, like oftentimes you'll hear the term white-collar crimes, things like fraud, like securities fraud or tax fraud, or sometimes mail fraud, things that like other things like racketeering or embezzlement. Those are crimes that are very closely related to business as well. So business law is usually, when people talk about business law, they're referring to something related to civil law. That does not always have to be the case. The Uniform Commercial Code, rather, is a uniform set of state business laws. So it was really created to help, starting in about the 1970s, and it was created to help standardize various aspects of the law so that businesses wouldn't have to worry about having to meet all of these different regulations in certain areas and so forth. So pretty much every state and U.S. territory has adopted parts of the Uniform Commercial Code, but there are only 2 states that have adopted it all, and those are California and Maryland. So let's talk about ethics and law. So ethics is basically a means of reasoning through what is considered morally right and wrong. And to conduct ethical reasoning, you have to use certain authority, like that can be a religious text or the laws of a certain jurisdiction. So some more definitions. Business ethics is basically the set of ethics that applies to business, and you use business ethics to make morally just business decisions. Impartiality is basically the consistent application of ethical standards regardless of the irrelevant characteristics of the people or the entities to which you are applying those standards. Utilitarianism is a term that describes certain ethical viewpoint, which relates to consequence-based ethics. So basically, utilitarianism believes that certain acts are right and wrong based solely on their outcomes, and that the act itself isn't right or wrong, but the act is considered right or wrong based on what outcomes it leads to. But deontology is more like a rule-based ethics. So the act itself is right or wrong, regardless of whether it leads to good consequences or bad consequences. But most laws end up becoming based on utilitarianism because of democracy, because something that affects a lot of people is more likely to be seen as harmful, even if it's right according to deontology, but it harms a lot of people, then it will still be seen by the people as wrong, and therefore it's much more likely to become criminalized. But civil rights and liberties protections are usually based on deontology because they're based on a broader rule about like an inherent idea that certain things are right and wrong. Usually, in most cases, when it comes to civil liberties, it's the idea that government doing certain things is always wrong, and that people have to be protected from that. So fidelity bonds are basically insurance policies that protect the business from embezzlement. Scofflaws are people who habitually break the law, and integrity is the ability to do what is right despite pressure to do otherwise. So civil disobedience is when there is an open and peaceful violation of law to show injustice. Martin Luther King had a set of reasons when a set of conditions when civil disobedience is justified, and they are that first, that a law conflicts with ethical reasoning; second, that formal means of changing the law are not realistic or probably not going to happen, they're not viable; and third, that the civil disobedience is non-violent; fourth, that it does not advance direct personal self-interest, so it's not something that solely exists to enrich one individual. It has like a broader there's a broader interest than just helping one or two people or a small group of people. And finally, fifth, it's that the civil disobedience is public and that punishment is willingly accepted. So those are the conditions that civil disobedience is justified according to MLK. Okay, so let's talk about some of the founding documents. So the first is the Declaration of Independence, which was drafted by Thomas Jefferson and adopted July 4th, 1776. July 4th is celebrated as Independence Day because of the adoption of the Declaration of Independence. And it declared that equality and natural rights are fundamental principles, and that King George III had allegedly violated them. The Articles of Confederation were basically the first constitution of the U.S., and it gave states extremely broad powers compared to what they have today. They have pretty much all powers, except declaring war, maintaining the military, treaty making, maintaining a postal system, and even though those powers existed for the federal government, the states had a lot of leverage, informal leverage, that they could use to basically change the decisions of the federal government or basically hamper them. There was only one branch of government at the federal level, which was a Congress, but it was nothing like the modern Congress because there weren't really elections for the Congress at the federal level. Instead, the state governments just picked people who basically served as ambassadors, and they would only have, each state had a single vote. So what would happen is when there's a vote, let's say there's like 5 delegates for a state, right? Instead of each of those delegates voting on their own, those delegates would basically huddle, and they would say, okay, so they would discuss the matter amongst themselves, and they'd be like, okay, each of them would take a vote internally. So they take a vote within their state delegation, and then whichever side of the majority, one of those delegates would go up and cast a vote for the state. So it wasn't super democratic. There was term limits, so delegates could not serve more than 3 years in a 6-year period. Legislation required 9 votes out of 13 to pass, which made it very hard to get anything done, and amendments to the articles required unanimity. So it was a very, very dysfunctional government structure, and after various rebellions and anger with the inability of the federal government to do much about those rebellions, the Constitution, the modern Constitution, came into being. But also with the Articles of Confederation, the states, there was no taxation power for the federal government, so the states had to basically voluntarily contribute funds. So what this meant is that the federal government was very dependent on the states, so it had very little. So even if it had the willpower to do something, if the states didn't want to do it, there really wasn't a whole lot that the federal government could do. So because of all these things, the state governments decided to call their own a convention called the Philadelphia Convention. Today it's more commonly known as the Constitutional Convention, to draft a new constitution, which is the modern Constitution, what we call today the United States Constitution. It was drafted in 1787 and took effect in 1788 after getting the requisite 9 ratifications. The ratifications from 9 of the states. So because of that, the new government The new federal government opened its doors on March 4th, 1789, and the Bill of Rights were ratified pretty quickly afterwards because a lot of the states insisted that a Bill of Rights be adopted as a first amendment to the Constitution. In exchange for their support of the ratification of the Constitution, the states demanded that the Bill of Rights be ratified to help protect civil liberties. So the first Congress that convened passed these amendments by 2/3 vote as required, and then it got 3/4 ratification. 3/4 of the state legislatures ratified by 1791. So the Bill of Rights, a lot of states had their own Bill of Rights, like in Virginia, New York were the most notable, and so that was an inspiration for the founders. But there are also some other sources, such as Declaration of Independence. They also looked at a lot of British documents, like the Magna Carta, the Petition of Right of 1628, and the Bill of Rights of 1689. So they looked at those documents. They looked at the Declaration of Independence. They looked at state constitutions, Bill of Rights, like in Virginia and New York, and based on all that, they drafted 10 amendments, which are now called the Bill of Rights. The First Amendment prohibits the establishment of a state religion, and also prohibits the free exercise of religion. It prevents the government from prohibiting or restricting the free exercise of religion. Also prohibits restrictions on the freedom of speech, press, assembly, and petition. Second Amendment is probably the most contested amendment of the Bill of Rights. There's still a lot of the Constitution is written in very old, dated language. So it's very difficult to determine exactly what the founders meant. So there's still a lot of historical and legal debate about what exactly the Second Amendment meant. But a lot of scholars, so some people argue that it means that individuals themselves have a right to bear arms, and other people argue that it was really more of a thing that was designed to protect the state militias from being disarmed by the federal government, and wanted to make sure that state militias had access to firearms so that they could continue running their operations. So in general, it protected the right to bear arms because of the importance of well-regulated state militia. However, in the last few years, the Supreme Court has read it to mean like a more individual kind of right to bear arms. But there's still a lot of restrictions on the right to bear arms. Like a lot of felons are still not allowed to bear arms. Obviously, children aren't allowed to have access to firearms and so forth. So the Third Amendment prohibits the quartering of soldiers in houses during peacetime. The Fourth Amendment prohibits searches and seizures without warrants that are very specific. The reason this was included is because oftentimes, even in the colonial, when Britain governed America, they still required warrants, but they allowed warrants to be very, very broad. So to remedy that, the warrant under the Fourth Amendment, warrants have to describe exactly what is to be searched, so that investigations don't just become a big fishing expedition. The Fifth Amendment prohibits double jeopardy, requires grand jury indictment for non-military felonies, and also requires due process and prohibits government takings without compensation. Sixth Amendment requires the right to public and speedy trial with the local jury, informs the defendant of charges, and requires the government to inform the defendant of charges, present, and even force witnesses to testify. Also requires the government to provide counsel for defendants. The Seventh Amendment requires that the juries be allowed to try civil cases where there's more than $20 at stake, and also requires that factual findings of a jury not be overturned by an appellate court. The Eighth Amendment prohibits civil or excess bail and cruel and unusual punishment. The Ninth Amendment says that there are other rights that exist, even if they're not explicitly laid out in the Constitution. And the 10th Amendment says that it basically protects states' rights, says that whatever powers are not explicitly stated in the Constitution as designated for the federal government, and whatever is not barred or not allowed for state governments to do under the federal Constitution, those powers belong to states. So let's talk about due process of law. Due process of law is basically a term that says that there has to be procedural fairness when the law is applied. So the 4th through 8th Amendments in the Bill of Rights protect due process, and the 14th Amendment, which is ratified after the Civil War, requires that states also protect those rights, not just the federal government. So slavery was implicitly allowed by the Constitution until the 13th Amendment, which was ratified after the Civil War. 15th Amendment prevented the states and federal government from denying the right to vote based on race. So basically, it enfranchised African Americans, even though a lot of southern states got around this by having like poll taxes, literacy tests, and all these things that were on the face of it seemed not to refer to race, or the race of any of the voters, but in practice they were applied in a very racially discriminatory way. So very few African Americans got the right to vote, even though they were entitled to it under the 15th Amendment. The 19th Amendment basically enfranchised women across the nation. There were many states, mostly in the West, that allowed women to vote even before the 19th Amendment, but then the 19th Amendment made it so that no state or the federal government could deny the right to vote based on the gender of a potential voter. The 26th Amendment basically lowered the national voting age to 18, so states could set the voting age for their state lower than 18 if they wanted to, but they could not set it higher than 18. So the highest they can now set the voting age is 18 because of the 26th Amendment. So the right to privacy usually invoked when people are talking about like abortion, but it's much broader than that. So it is protected by the Constitution because of mostly abortion cases like Roe v. Wade and so forth. But there are also some federal and state statutes that protect privacy in other contexts that are more relevant to business. So, for example, in the United States, it's illegal there's a common practice on the internet where websites will often collect cookies, which are basically data about the website visitors, and they will use that data to basically, some websites might sell the data to other providers, or they might use the data to be able to they might buy other data from other providers to kind of get a broader idea of what you want. They'll try and market things to you based on that data. And video and cable TV providers are not allowed to do that in the U.S., but they are allowed to do that. But website providers are allowed to do that in the U.S. But because of the EU, in the EU, a lot of these things aren't allowed. There was a major law that the EU passed in 1995 that prohibited this practice. But the U.S. still hasn't outlawed the collection of cookies. Under the EU General Data Protection Regulation, it contains a lot of various data privacy laws, data privacy protections, and it also specifies that member states of the EU cannot allow the transfer of data to nations that lack sufficient data privacy protection. So what this means is that in the context of business, is that American companies, when they're abroad, when they're doing business in the EU, they might have subsidiaries in the EU countries, right? So if those EU country subsidiaries, they collect certain data, they can't transfer that back to their American headquarters. That's illegal under the EU GDPR, because if they do that, then they'll get a fine, because the US doesn't have the kind of data privacy protections that most of the EU has, and a lot of other countries around the world have. Let's talk about regulatory agencies, because they play a very, very important role for business, because they're a way for Congress to exercise its power to regulate interstate commerce under Article 1, Section 8 of the Constitution. So over the years, Congress has created various regulatory agencies to address various problems it is seen with mostly exploitative business practices. But, for example, the Federal Reserve was created in the early 1900s, and it basically serves as the American central bank. It controls the money supply, like the amount of money that's circulating in the economy, and also controls interest rates. It controls the interest rates that it lends to other banks at, and then that indirectly influences the interest rates in the economy writ large. So if you ever heard of OSHA, which is under the Department of Labor, it's an agency that regulates health and safety in the workplace. So there are a variety of regulations related to various types of workplaces and so forth that it sets out. The Food and Drug Administration tests drugs, enforces the various pure food and drug laws, also inspects food products. The FDA is under the Department of Health and Human Services. The EPA is an independent agency. That means it's not under any of the 15 cabinet agencies. And its main job is to enforce the various pollution laws. It was created by a law that President Nixon signed back in the 70s. So then we have the National Labor Relations Board, which was created in the 1930s as a result of various New Deal legislation, and it basically enforces labor law, and it also referees the union formation elections. So you guys might have heard about the Amazon. There were workers in an Amazon plant in Alabama, or an Amazon warehouse in Alabama, who wanted to form a union. So oftentimes when you read the articles about this election, you would hear they would say, the workers want to appeal to the National Labor Relations Board because they think Amazon, did a certain exploitative or illegal practice when they were campaigning in this election. So the NLRB is in charge of basically serving as a referee during those elections, counting the votes, watching for violations, and so forth. The Federal Communications Commission is an independent agency that regulates interstate and international airwaves. The FTC was created in the early 1900s, and it enforces many of the antitrust laws and the consumer protection laws. The SEC is very, very important because it regulates stock exchanges. It also regulates a lot of disclosures related to sale of stocks and bonds. A lot of public companies that you can buy shares of on the stock market, they have to do certain kinds of disclosures of their earnings, their shareholder meeting results, certain compensation things, and so forth. You have to disclose a lot of information because of this Securities and Exchange Commission regulations. Consumer Product and Safety Commission enforces a lot of consumer safety laws, and the Nuclear Regulatory Commission enforces laws around nuclear power plants, and it also creates regulations to ensure the safety of those nuclear power plants. So let's talk about the history of the internet, because there are a lot of laws surrounding the internet and a lot of interesting issues that have arisen in the law because of the existence of the internet. So the internet really started or in the 1990s, but the predecessor of the internet was ARPANET. It was created way back in the 1960s. It was really just used as a means of transmitting information really quickly, so that defense, so scientists who worked for the DoD could get a lot of their data and their results a little bit faster, and they could send not so much get the data faster, but they could transmit it to other researchers faster, so they wouldn't have to wait. So the researchers wouldn't have to wait for data to come in from other researchers. So the National Science Foundation helped create the modern internet as we know it, that was used outside of just the Defense Department. But until 1991, it wasn't allowed to be used for business. It was just something that a lucky few individuals got to use. It was not even close to as sophisticated as it is today. But when hypertext was developed, which is basically a non-linear system of sending information through something called packets of data, that basically revolutionized the internet. And so coming off of that, so HTTP is a protocol that's used for the internet, and we have HTML, which is the coding language of the internet. So in the 1990s, Tim Berners-Lee developed the so-called World Wide Web, which helped democratize the internet and allowed ordinary people to access the internet as long as they had a simple downloadable browser on their computer. So pretty much all you needed now. So you didn't have to go through the DoD or the National Science Foundation. All you needed now to access the computer to access the internet after the World Wide Web was created was a computer and an internet browser, which basically scanned through the hypertext. And so because of that, pretty much anyone with a computer was able to access the internet. So HTTP allows the internet to be a web-like system. And the important thing when it comes to the lands of business law, the significance of the internet being a web-like system is that it's much harder for the government to take things down. So when something on the internet violates a law, it's very, very hard to take it down. Like if confidential information is released on the internet, like with WikiLeaks, right? It's very hard to get rid of that information, take it down from the internet completely, because it's very decentralized. There's no one single individual or company or institution or organization that controls the entire internet. So once certain thing is on the internet, it's very, very likely that the information will just quickly spread. It'll be on various computers, various connecting points, paths, storehouses of information, and so it's almost impossible to take it down. And even if you do succeed taking down, if the government succeeds in taking down something that's illegal on the internet, it may be possible that individuals might have downloaded it off the internet, taken an image of whatever is illegal, and put that on their phone or their iPad or whatever it may be, right? So it's almost that's the main implication of the internet being a web-like system, because it makes it very, very hard for the government to take down illegal things that are on the internet. Cyber law is basically the law that governs e-commerce and the internet more broadly. There's several statutes that are very important when it comes to the internet. First is the Lanham Act, which protects copyrights and trademarks. The Computer Fraud and Abuse Act criminalized various computer crimes. So, for example, the theft of confidential data. Before the Computer Fraud and Abuse Act, whenever the government, prosecuted someone for stealing confidential data, oftentimes the individual who's accused would get acquitted because traditional theft laws didn't really apply, because if you think about it, all that they were really stealing was not, like, what they were stealing wasn't a physical object. It was just packets of data that you can't really see at all. So it was very hard for like judges just didn't buy that they were really stealing anything that the law criminalized. So that's why the Computer Fraud and Abuse Act was passed, and it criminalized various computer crimes for the first time. So the Trademark Dilution Act of 1996, for the first time, it prevented famous trademark owners from having others use their trademarks or create very similar trademarks and put that on the internet. It really was created, the law was created because of the internet, because the internet made it very easy to modify these logos, these trademarks, and basically profit off the trademarks while hiding beneath the fact that technically you weren't copying the trademark, but in reality you kind of were. You were just making these super minor modifications that were just designed to basically skirt the law. So that's why this new law was created. But the law was revised in 2006. The Communications Decency Act of 1996 has a lot of different provisions, including Section 230, which is kind of famous for a variety of reasons. But one of the main things that the CDA did was it outlawed the transmission of so-called indecent material on the internet and provided for imprisonment, but the Supreme Court nullified the provision because of the vagueness of the word indecent, because it violated First Amendment, because the word indecent was seen as too vague and too broad. So that's why that provision of the CDA was nullified. The Child Online Protection Act 1998 was also struck down for violating the First Amendment, and this time it was struck down in its entirety, unlike the CDA. Most sections of the CDA are still in effect, but the Child Online Protection Act is basically null and void, pretty much, because it violates the First Amendment. So it had a lot of provisions that basically required companies to self-censor themselves and restrict access to material that's supposedly harmful to children using the latest technology, but it's struck down because a lot of companies couldn't really afford that, and also because it potentially chilled free speech. So the internet has a lot of jurisdictional issues, right? Because traditionally, because it creates issues of where does an internet company or a company that is doing business over the internet reside, and where should it have to defend lawsuits. For example, the main question of jurisdiction goes something like this, right? Should a business in Georgia have to defend a lawsuit in a Florida state court if, for example, if it was doing business over the internet and somebody in Florida wanted to buy something and that resulted in a lawsuit? Does the Georgia business have to defend its lawsuit in Florida? And the answer is usually yes, because most states have what are called long-arm statutes that require businesses to defend these kinds of lawsuits. So in Burger King Corporation versus Radisowitz, the Supreme Court decided that the defendants in that case could be sued in federal court in Florida, even though they resided in Michigan, and the only things that they did to interact with Florida residents were like getting paperwork and training from the Burger King headquarters in Florida. So even though their business was entirely in Michigan, they still had to defend a lawsuit in the Florida's federal court. So a lot of companies, to basically address a lot of these jurisdictional issues, a lot of companies, what they'll do is they'll have clauses that are buried within their contracts, and these clauses will require the lawsuits to be decided in a certain jurisdiction favorable to the companies, so that the companies have a greater chance of winning those kinds of cases. So there are some other cases that are important when it comes to the Constitution of the Internet. So in Roth v. U.S., the SCOTUS Supreme Court first held that obscenity is not protected by the First Amendment, but it also tightened the rules on obscenity, so it made it much harder for an obscenity case to succeed. So it set a very much more tough standard. But then in Miller, the Supreme Court also tightened the standard even further and added two additional components to the rules. So now instead of a piece of work or something meeting just one condition, it now had to meet three different conditions. So it's much harder for these kinds of prosecutions or civil cases for obscenity to succeed. And both of these cases were decided pretty close in a close vote. So Roth was decided on I believe on a 6-3 vote, and Miller was decided on a 5-4 vote. So so these kinds of cases, so the case law on obscenity and a lot of internet issues can really change pretty quickly because the composition of the Supreme Court, and also because the technology is developing pretty quickly and much faster than the law develops. So after the internet was created, there was basically new case law that held that the recipients community under the Miller test referred to the community referred to in the Miller test was going to be the recipients community. So you can see that when it says the average person applying contemporary community standards, when trying to determine what is considered obscene, you have to apply the recipients community. So that means that if a company is doing business over the internet, then something that's obscene, say in Florida, might not be obscene in Idaho or Oregon or whatever it may be. So that's another consideration that businesses have to keep in mind. So I hope you guys enjoyed my video on Chapter 2 of Adamson's Law for Business and Personal Use, preparing you for the FBLA Business Law Objective Test competitive event. And hopefully we'll see you next time.